Welcome to the deep dive. So imagine you're an educator in South Africa, stepping into a public school classroom. Well, pretty much every part of your professional life, how you get hired, your salary, what's expected, even retirement. It's all shaped by one really key piece of legislation.
That's right.
And today we're doing a deep dive into that exact document, the Employment of Educators Act 76 of 1998. Our goal here is simple. Pull out the most important bits, the real nuggets of knowledge from this act.
Make it clear, make it engaging.
Exactly. Whether you're just curious about how our education system works, or maybe you're a law student looking for a solid overview.
And it's really not just some dry legal text gathering dust. It's more like a living, breathing framework, It directly impacts thousands, tens of thousands of professional lives.
A living framework. I like that.
Yeah, and what's fascinating is how it builds this structure for, well, stability, but also accountability. And it's always evolving.
Always changing.
Constantly. In fact, the latest updates were folded in as recently as December 2024. That tells you how vital, how responsive it still is.
Okay, so let's start at the beginning then. What was the big idea behind it? What was Parliament aiming for back in '98 when they put this act together? Why was it needed?
Well, at its absolute core, the act was set up, and I'm quoting here slightly, to provide for the employment of educators by the state, for the regulation of the conditions of service, discipline, retirement, and discharge, and matters connected therewith.
Right.
So basically, it formalizes that whole relationship. The state is the employer, the educators are the employees. It creates one single unified legal basis for all those critical parts of an educator's job.
Got it. And you mentioned it's a consolidated act. Now, for listeners maybe not up on legal jargon, what does that actually mean? How does that affect its relevance today?
Good question. And it's really key to understanding how laws like this work. Consolidated means it's not static. It's not stuck in 1998.
Okay.
It means all the amendments, the updates over the years, they've been woven directly into the main text. Think of like a shared document that's constantly updated, not an old printed book.
Right, so it incorporates changes.
Exactly. It's been shaped by lots of different education laws, amendment acts, other related laws like the South African Council for Educators Act, you name it. This continuous evolution, this updating, means it adapts.
It adapts to what?
Societal changes, new needs in education, shifts in how things are governed. It keeps it relevant, keeps it effective, stops it from becoming, obsolete.
That makes perfect sense. It has to stay current. So building on that, let's zoom in a bit. Who exactly does this act cover? When it says educator, are we just talking about the teacher at the front of the classroom? Or is it wider than that?
Oh, definitely wider. The act defines an educator as, let me get the wording right, any person who teaches, educates, or trains other persons, or who provides professional educational services.
Professional services. Oh.
Including professional therapy and education psychological services at any public school or departmental office, and who is appointed in a post on any educator establishment under this act.
Okay, so not just the subject teacher.
Not at all. It includes school psychologists, therapists, anyone providing those professional educational services.
Yeah.
If you're in a professional role within the state education system, this act likely applies to you.
That's a really important distinction, which brings us to where they work public schools and departmental offices. How does the act define those places?
Okay, so public school is pretty straightforward. It's what's defined in the South African Schools Act, the ZASA from 96.
Right.
A departmental office, though, is different. It's any office or institution run by the Department of Basic Education or a provincial department, but, and this is key, it excludes public schools.
So like admin offices, support centers.
Exactly. Administrative hubs, support services for the system. And interestingly, you see how things change because definitions like adult basic education center, they've actually been deleted over time.
Why is that?
Well, it reflects shifts in how those parts of the education sector are managed, maybe under different laws now, or just how the Act's focus has been refined over the years.
This leads to a big question then. Who's the actual employer? Because it sounds like it could be different people depending on the situation.
You've hit on a really crucial point. It's quite nuanced, this multi-layered employer thing. It's actually fascinating by design.
Okay, break it down for us.
Right. So for most day-to-day employment stuff, within the National Department of Basic Education, the Director General, the DG, is the employer.
Okay, the DG nationally.
Then for the provincial departments, it's the head of department, the HOD.
HOD provincially. Got it.
But And this is big. But when it comes down to setting salaries and the big conditions of service for all educators everywhere,
Yes.
that's the Minister of Basic Education.
Okay. The minister steps in for the big picture on pay and conditions.
Precisely. And then for actually creating the posts, the minister does it nationally, and the member of the Executive Council, the MEC, does it for the provinces.
Wow, okay.
And it gets even more layered because a public school itself can sometimes be the employer for other staff.
So it's complex.
It is. It creates this system of sort of checks and balances. But it also means, as an educator, you might be dealing with different employers depending on what the issue is. A salary query goes one way, maybe a grievance another.
That definitely adds nuance. So for the educators listening right now, let's talk about something very real. Salaries and the posts they actually hold. How are those decided and set up?
Right. This is absolutely critical for every single educator. The minister, working with the Minister of Finance, determines the salaries and other conditions.
With finance, okay.
But here's what's really interesting. The Act says this is done notwithstanding anything to the contrary contained in any law, but subject to the Labor Relations Act or any collective agreement concluded by the Education Labor Relations Council.
Whoa, what does that mean in plain English?
It means that even though the minister sets the overall framework, collective bargaining unions negotiating through the Education Labor Relations Council plays a huge role.
So educators have a voice through their unions.
A significant voice. It's
Yeah.
baked into the process. Plus, the Act allows for flexibility, different salaries, different conditions for different ranks, grades, or even sectors of education. It acknowledges the diversity in the profession.
Okay, so the minister handles the money side with union input. But who actually creates the jobs, the educator establishments, the specific positions?
Good question. Nationally, for the Department of Basic Education, the minister creates these posts.
Minister again.
Provincially, it's the MEC, the member of the Executive Council.
Okay, MEC for the provinces.
Then, once those posts exist on paper, so to speak, it's the head of department, the HOD, who actually allocates them to individual schools or offices.
Following rules, presumably.
Always. Following specific norms for provisioning. And this power isn't just about creating posts. It also includes the power to grade them, change their designation, convert them, or even abolish them entirely.
It gives them flexibility.
Exactly. Essential for managing resources effectively as needs change across the whole system.
Right. This is where it gets really interesting for anyone starting out or maybe looking to move up. Appointments, promotions, transfers. Who holds the reins there?
Okay, generally speaking, the DG handles this nationally and the ONG provincially. That's the default.
But, I sense a but.
But, and this is a big one, especially for public schools, any appointment, promotion, or transfer to a post at a public school has to be made on the recommendation of the school's governing body.
The SGB, wow, that's significant power at the local level.
It really is. It gives the school community, through the SGB, a direct say in who teaches their kids. It's often a point of discussion, let's say.
I can imagine. So what process do the SGBs have to follow? They can't just pick favorites, surely.
No, definitely not. The process is quite specific. The governing body has to ensure they comply with principles like equity, redress, representativity.
With core constitutional values.
Exactly. And follow democratic procedures set by the minister. Critically, they also have to check the candidate is registered with ACE, the South African Council for Educators.
ACE registration, okay.
Yeah, they submit a list, usually at least 3 recommended names, sometimes fewer if they've talked to the HOD first.
Okay, what if the SGB messes up? Or maybe just doesn't make a recommendation quickly enough? Schools can't just sit empty, right?
Absolutely not. And that's where the HOD comes in again, acting as a crucial safeguard.
How so?
If the SGB hasn't followed the rules, maybe their process was flawed, the HOD must decline the recommendation.
Okay, decline it. Then what?
Then the HOD can step in, look at all the applications themselves, apply the proper criteria, and either make a temporary appointment or just re-advertise the post.
So the AG takes over the process.
Effectively, yes. And even more directly, if the SGB simply doesn't send a recommendation within 2 months of being asked, the HD can just go ahead and make an appointment without it. It ensures posts get filled. There's also an appeal route for SGBs to the MEC if they disagree with certain HOG actions, like temporary appointments.
That makes sense. A backstop is needed.
And there are other practicalities covered too, like for someone's very first job as an educator, or if they're coming back after a long break.
Yes.
The employer can handle those applications directly. And if someone's already in a temporary post, the HG can make it permanent after just consulting the SGB, not necessarily needing a whole new recommendation.
So flexibility seems key.
It has to be for practical staffing on the ground.
What about moving around? Say an educator wants to transfer to a different school, maybe even a different province.
Transfers are definitely possible between departments within the same department. Again, though, if it's a transfer to a public school post.
Let me guess, SGB recommendation needed.
You got it. Recommendation needed. Or, same fallback. If no recommendation comes in 2 months, the HUD can proceed. Also applies to temporary transfers.
Okay.
And importantly, an educator's salary and conditions can't be made worse by a transfer unless they agree in writing. Except in specific disciplinary situations we might touch on later.
Protection for the educator there.
Yes. And there's also something called second comment. That's where an educator can, with their consent, be temporarily placed somewhere else, another department, maybe even an outside body, for a specific task or time, but they still remain technically employed under this act.
Interesting. Okay, let's shift gears slightly. It's maybe less pleasant, but just as crucial. How does the act handle the end of an educator's service? Retirement, discharge.
Right. Vital for career planning, even if it's the end point. Let's start with the retirement. Generally, the rule is educators have the right to retire, and the standard retirement age is 65.
65, okay.
But there's quite a bit of flexibility built in. An educator can choose to retire anytime from age 55 onwards.
Voluntarily from 55?
Correct. And even before 55, the employer can allow early retirement if there's a really good reason, and it's seen as beneficial to the state.
Okay.
Plus, there are historical clauses protecting educators employed before certain dates in the mid-90s, allowing them to retire based on the rules that applied back then. Ensures fairness for long-serving staff.
So retirement has options. What about being discharged? That sounds more like termination.
It generally is. The Act lists several grounds for discharge. One is continuous ill health, and there's a whole detailed process for that in Schedule 1 we can look at.
Okay, ill health is one. What else?
Operational reasons are another category. Things like the abolition of your post, maybe general staff cutbacks, or big reorganization aimed at efficiency.
So things outside the educator's control sometimes.
Sometimes, yes. Then there are reasons related more to performance or conduct. Things like being found unfit or incapable of doing your duties.
Incapacity.
Misconduct, which is a big topic with its own procedures in Schedule 2.
We'll definitely get to that.
Also, if you misrepresented yourself when you were appointed, lied on your application, say, or if you were appointed on probation and just aren't confirmed in the post.
That's quite a list. What about this idea of being deemed to be discharged? That sounds quite automatic.
It does, and it's something every employee should be aware of, really. If an educator who's permanently employed is absent without permission for more than 14 consecutive days.
Just doesn't show up for over 2 weeks.
Right. Or if they take another job while they're absent without leave or suspended or facing disciplinary action, they can be deemed to have been discharged because of misconduct.
Automatically fired.
The Act sets effective dates, making it seem automatic. But, and this is crucial, there's a safety net. If that educator later shows up and can provide good cause shown for their absence,
A valid reason.
reinstatement is possible. It's not necessarily a closed door forever. It avoids automatic termination without any chance to explain.
That's an important protection.
Definitely. And just quickly on resignations, the standard is 90 days written notice, though the employer can agree to shorten that.
And anything else on ending service?
One very significant point. If an educator's name gets struck off the register by SACE,
The professional counsel.
they're automatically deemed to have resigned. Their permission to practice is gone, so their employment under the Act effectively ends too.
Wow. Okay. That links registration directly to employment. Now, this brings us squarely to upholding standards, incapacity and misconduct. Let's start with incapacity, poor performance, or ill health.
Right. The Act gets very specific here using two detailed schedules. Schedule 1 handles incapacity. It covers both poor work performance and ill health or injury.
Okay, let's take poor performance first.
For poor performance, the approach is meant to be supportive, structured. The employer has to assess the educator's capacity, give them written reasons for concern, meet with them, and they can bring a union rep or colleague.
Important.
Definitely. They need to explain the job requirements clearly, evaluate the performance, point out where it's falling short, and then, usually, develop a formal program, counseling, training, support.
So try to fix the problem first.
Absolutely. Termination is really the last resort, only considered after there's been an inquiry and the educator has had every chance to respond and improve.
And what about incapacity due to ill health or injury?
Similar focus on process. The employer investigates, gives the educator a chance to state their case. They can appoint doctors at the state's expense for examinations, with strict confidentiality rules.
Medical assessment.
Yes. Based on those medical reports, the employer figures out if the ill health is temporary or permanent. They have to explore options. Can we find alternative work? Adapt their duties before jumping to termination. It's designed to support the educator through illness where possible.
So incapacity sounds quite process-driven, supportive even. Misconduct, though, that feels different. More serious breaches.
It generally is. And Schedule 2 lays out the disciplinary code and procedures. The Act makes a key distinction here between serious misconduct in Section 17 and a broader category of general misconduct in Section 18.
Why the distinction?
Because the consequences are different. It signals the severity.
Okay, so what lands in the serious misconduct bucket, and what happens if you're found guilty?
Right. Section 17 lists acts where, if proven, dismissal is mandatory. Required.
Mandatory dismissal. Okay, like what?
We're talking really grave offenses: theft, bribery, fraud, especially exam fraud. Crucially, sexual assault or having a sexual relationship with a learner.
Absolutely critical line there.
Totally non-negotiable. Also, seriously assaulting a learner or another employee, illegal drug possession on school grounds. These are things that fundamentally break the trust required. The Act is very clear. These warrant dismissal, providing strong protection for learners and upholding core professional ethics.
Okay, so that's the really serious stuff. What about the broader misconduct under Section 18? What does that cover?
Yeah, Section 18 is much wider. It covers a whole range of actions that constitute, as the Act puts it, a breakdown in the employment relationship.
Breakdown? How?
We could maybe group them. There's stuff around honesty and administration, like mismanaging school funds, misusing state property.
Financial issues.
Then there are breaches of duty and ethics, being insubordinate, unfairly discriminating against someone, even falling asleep on duty.
Basic professionalism.
Exactly. And actions that compromise safety or the learning environment, endangering lives, inciting others to break rules, maybe assault that isn't deemed serious as under Section 17.
Yeah.
It's a very comprehensive list, trying to cover behavior unbecoming of an educator.
It sounds like it covers a lot of ground. What are the potential consequences here? It's not automatic dismissal like Section 17, right?
Not necessarily automatic dismissal, no. The sanctions can vary a lot, depending on how serious the misconduct was, its impact, the educator's history, and so on.
So what kind of range are we talking?
It could be anything from counseling, a verbal warning, a formal written warning, up to a fine that can actually deduct up to 1 month's salary.
A fine, okay.
Or suspension without pay for up to 3 months, demotion to a lower rank or salary level, or, yes, dismissal if the misconduct is serious enough to warrant it, even if it's under the general Section 18 category.
So even some Section 18 offenses can lead to dismissal?
Yes, things like dishonesty, proven unfair discrimination, certain criminal convictions like rape or murder, or breaking specific rules in the Schools Act, those can still lead straight to dismissal. The key is that there's a disciplinary procedure, a fair hearing, before any sanction is imposed.
Due process, very important. Now, you mentioned recent updates. I saw a new Section 19 added about conducting business with the state. That sounds pretty significant.
It is significant and very recent, added by Act 32 of 2024. Section 19 is quite blunt. An educator may not conduct business with the state or be a director of a public or private company conducting business with the state.
A clear prohibition.
Absolutely. And the consequences for breaking this rule are severe. It's treated as both a criminal offense, potentially facing a fine, or up to 5 years in prison.
Wow.
And it constitutes serious misconduct under this act, which, as we just discussed, leads to termination of employment.
So a double whammy. Criminal and employment consequences.
Exactly. It's a very strong measure aimed squarely at preventing conflicts of interest and potential corruption within the public education sector. A real tightening of ethical standards.
Understood. Finally, on this section, what if an educator disagrees? They go through an incapacity process or a disciplinary hearing, and they think the outcome, the finding, or the sanction is wrong or unfair. What can they do?
Good question. Fairness requires recourse. The Act provides for appeals under Section 25.
Appeals to whom?
An educator can appeal decisions about demotion, transfer, or termination that resulted from the incapacity process. That appeal goes to the minister or the provincial MEC.
Okay, for incapacity outcomes.
And similarly, for disciplinary outcomes like fines, suspension, demotion, dismissal, both the educator and the employer can appeal the finding or the sanction. Again, to the minister or MEC.
The employer can appeal too. Interesting.
Yes, maybe they think the sanction wasn't harsh enough, for instance. Schedule 2 lays out the detailed procedure for these appeals. It provides that essential layer of review, a check on the decisions made initially.
Ensures another set of eyes looks at it.
Precisely. A crucial part of ensuring the system is fair.
Okay, so pulling this all together now, we've covered appointments, conditions, retirement, discipline. What does this act mean in the day-to-day? How do the general provisions affect educators and the system?
Well, the Act tackles several practical everyday aspects. For example, Section 33 deals with performance of other work.
Moonlighting.
Essentially, yes. Educators need to put their time at the employer's disposal. They generally can't take on other paying jobs outside their official duties without getting permission first.
Why is that?
Helps manage potential conflicts of interest, ensures their energy and focus are on their main job educating. Also, they can't claim extra pay for duties they volunteer for or are ordered to do as part of their role.
Okay, clear boundaries there. Anything else?
There are also offenses and penalties in Section 34. This is about ensuring cooperation with the formal processes. For instance, if someone is summoned to a disciplinary inquiry and they just don't show up or they refuse to testify.
They obstruct the process.
Yes. That itself can lead to a fine or even imprisonment. It underlines the seriousness of these inquiries.
Right.
And perhaps most significantly for ongoing management, Section 35 empowers the minister to make detailed regulations. This is huge.
Regulations on what?
All sorts of things. How to recover money paid irregularly, how posts should be advertised, setting up selection boards. And critically, it mentions new norms and standards for district staffing.
District staffing. So how resources are allocated across areas.
Exactly. This power to make regulations means the Act doesn't need constant amendment for every little detail. It allows the system to be responsive, to fine-tune implementation based on current needs without going back to Parliament every time.
Makes the act more agile, in a way.
In a very important way, yes.
So stepping back for the big picture view, it's clear this is a really comprehensive framework dynamic, too. What's the real-world significance for you listening now and for the education sector overall?
Well, if you connect all these dots, this Act basically provides the entire legal skeleton for employment and public education in South Africa.
The skeleton.
Yeah, the structure, everything else hangs on. For educators, it offers a degree of stability, predictability. It clearly lays out rights, responsibilities, processes.
And for students, the public.
For them, it provides vital mechanisms for accountability. Think about those strong provisions against serious misconduct that's about protecting learners, ensuring professional standards in the classroom.
Holding educators accountable.
Yes. And it also maps out that complex dance of power between national government, provincial departments, and even the local school governing bodies. It structures how this huge public service is staffed and managed.
And the constant updates you mentioned.
They show it's not a relic. The continuous amendments, like the recent Section 19 on business dealings, prove it's adapting. It's trying to maintain its integrity, its effectiveness, as society and its challenges evolve.
What an absolutely fascinating deep dive into the Employment of Educators Act 76 of 1998. We've really unpacked how this consolidated act sets out the purpose, the key rules, the legal backdrop, what it means in practice.
From getting hired, getting paid.
Right, through development, handling problems like incapacity or misconduct, all within this living legal context. It really is the foundation stone for public education employment.
Absolutely. And understanding these kinds of cornerstone acts, I think it helps us appreciate the intricate legal machinery that underpins critical public services.
It's not just rules on paper.
No, it's really a testament to that ongoing effort trying to build fairness, accountability, and hopefully quality into our education system and constantly refining it, updating it to make sure it actually works.
So what does all this mean for you listening? It means every single time an educator walks into a public school classroom, their job, their rights, their duties, they're all governed by this incredibly detailed legal framework. A framework designed ultimately to protect both the professional educator and the learners they serve. As you think about everything we've discussed today, here's something to mull over. How might the ongoing evolution of this act, the future amendments, the new regulations, how might that further empower educators to innovate, to excel, and ultimately to lift the standard of education for every learner in South Africa in the years ahead?